All right, welcome. Today we're tackling an absolutely essential revision topic for Year 2 Law of the European Union. We're diving straight into a comprehensive explainer on the legal architecture of the EU and, its incredibly complex, both historical and modern relationship with the UK. So whether you're gearing up for exams or just want a really clear, structured breakdown of how this massive legal system actually operates, you are in exactly the right place.
Let's kick things off with a pretty provocative constitutional question to frame our whole revision session today. How did joining a European community fundamentally and permanently change the rules of UK parliamentary sovereignty? I mean, for centuries, the absolute supremacy of the UK Parliament was the bedrock of the British legal system. Yet, as we'll see, integrating into the European network meant handing over some major legislative, executive, and judicial powers. Understanding exactly how and why this happened, well, that's your key to mastering this subject.
So here's our roadmap for today's explainer. We're going to break down these dense constitutional principles into 4 clear, memorable building blocks. First, the sources of EU law, then supremacy and supranationalism, next, the power of direct effect, and finally, EU law after Brexit. These 4 compartments are just perfect for structuring your exam knowledge.
Okay, block number 1, sources of EU law. Let's see how this legal framework builds right from the ground up, starting with the very highest forms of law.
Now, European Union law isn't just one giant rulebook. It actually stems from several distinct categories of law that dictate exactly how power is exercised within member states. To really get EU law, you've got to understand its hierarchy.
And here is that 4-fold hierarchy. Sitting at the absolute top are the internal treaties and protocols, specifically things like the TEU and TFEU. Think of these as the constitution of the EU. Right below the treaties, we've got international agreements negotiated by the EU on behalf of its members. Then comes secondary legislation, which we'll break down in just a sec. And finally, we have the decisions of the Court of Justice of the European Union, or the CJEU. Now, even though the EU doesn't have a formal system of binding precedent like English common law, the CJEU's case law is incredibly prominent. It's what ensures legal certainty across the whole Union.
Now, here is a vital distinction you absolutely need to nail for your exams regarding that secondary legislation. Regulations apply automatically. The second they are passed in Brussels, boom, they are legally binding in all member states. No further action needed. Directives, on the other hand, are completely different. They simply set a specific objective, right? A goal. And then they require the individual member states to actively pass their own domestic laws to hit that goal by a set deadline. It's actually a brilliant way for the EU to harmonize laws while still giving local governments the flexibility to implement them in a way that actually fits their own domestic systems.
Moving on to our second block, supremacy and supranationalism. Let's see how this hierarchy creates some serious constitutional tension between UK domestic law and the EU's legal order.
To understand the rule of supremacy, we first have to wrap our heads around supranationalism. Unlike federalism, where states give up their sovereignty entirely, supranationalism is a method where sovereign member states voluntarily limit their own powers to participate in an autonomous network. They delegate sovereign powers to the community. But what does that actually mean in practice? Well, it means they might be forced to implement a decision taken by a majority vote that they explicitly voted against. The community's interests simply prevail over individual national interests.
There's a great quote from Cruz that captures this reality perfectly. Without supremacy, community law ceases to be communitaire. The whole EU legal structure is built on mutual trust and shared values. Because of that, its laws absolutely must trump national laws when conflicts arise. Just think about it. If every member state could just use their own national laws to override EU rules whenever they felt like it, the entire system would just collapse into chaos. Supremacy was a totally necessary invention by the Court of Justice to make sure things stayed uniform across the entire Union.
So, the crucial point for your revision is how this actually played out in the UK. Because the UK has a dualist legal system, EU law had to be brought into the country via the European Communities Act 1972, and under Section 2 of that act, UK courts essentially became EU law courts. This led to some dramatic constitutional showdowns, most famously the Factor Tame case. In that instance, UK judges were suddenly empowered, and actually required, to effectively strike down or disapply sovereign acts of the UK Parliament if those acts conflicted with European law. I mean, that was a massive, totally unprecedented shift in British legal history.
All right, on to our third thematic block, the power of direct effect. Let's look at the actual mechanism that allowed everyday citizens to use these supreme EU laws in their local courts.
Established early on in the famous Van Genden Loos case, direct effect was a total game changer.
Basically, it means that if a piece of EU law is mandatory, clear, unconditional, and precise, an individual citizen can rely on it and enforce it directly in their own national court. For example, our sources mention a litigant named Dr. Meyer. He was able to challenge German national law just by invoking Article 34 of the EU treaty directly. He didn't have to wait around for Germany to fix its laws. The EU law directly armed him with rights he could use right then and there.
Now, direct effect comes in two distinct flavors. Vertical direct effect is when you, as an individual, rely on EU law to take action against your government or a state body. Horizontal direct effect is when you use an EU provision against another private individual or company. Treaties often have both, but keeping this distinction clear is incredibly important when you're tackling those complex exam scenarios that involve different types of secondary legislation. Notice how these two massive concepts, supremacy and direct effect, form this completely symbiotic relationship. Think of it like a puzzle. Without supremacy, direct effect would be completely useless, right? Because a national law could just overrule the individual's EU rights. And conversely, without direct effect, supreme EU laws would just be these theoretical ideas floating around in Brussels, completely useless to everyday citizens trying to enforce their rights locally. Together, they are what make EU law real and powerful.
Which brings us to our fourth and final building block, EU law after Brexit. Let's explore how this entire supranational framework functions in the UK syllabus today. Because, obviously, the UK left the EU, so why are we still studying it?
Let's trace this legislative unraveling. We started back in 1972 with the European Communities Act, which originally embedded EU law into the UK. Then, of course, came Brexit. The Westminster Parliament passed the EU Withdrawal Act in 2018. Now, what this act did was fundamentally take a snapshot of almost all EU law as it applied at 11 a.m. on December 31, 2020, and made it domestic UK law, branding it retained EU law. Fast forward to the start of 2024, and under the new Retained EU Law Act 2023, this entire body of law officially became known as assimilated law. The reality here is that the UK was deeply integrated into the EU's legal and economic system for nearly 50 years. Substantial parts of English law were profoundly shaped by the EU, so the 2018 Act had to onshore these laws. We're talking enormous swaths of commercial law, employment rights, discrimination laws, and environmental protections essentially copied and pasted directly into domestic UK law. And they had to do this to prevent total overnight legal chaos. If they had just deleted all EU influence on Brexit Day, entire sectors of the British legal system would have literally collapsed.
Which leaves us with this final provocative thought as you wrap up your revision. Even though the UK has technically taken back control of its sovereign powers, how much of our legal system is still secretly European? As you go on to practice law today, be acutely aware that a lot of the domestic laws you'll be working with are actually just European concepts built on decades of supranational integration, now simply wearing a different hat. Best of luck with your revision, and I'll catch you in the next explainer.